Hi there. Welcome to Help Solve the Case. Christine Burke here, retired police detective and sergeant, law enforcement expert, forensic genetic genealogist, lover of all things criminal justice. Thanks for being here. Today, we are looking at, just by way of interesting, another conviction that is overturned from junk science. Okay. Some of the expertise that has been presented in the courts in past history has been ruled junk. Okay. And unfortunately, it's convicted a lot of people. And this gentleman looks like he got not only his life spared, but was freed from prison. So let's get into it. Okay. So I just find this is an interesting story because I've heard certain things about this type of evidence. And we've had some convictions overthrown because of this type of testimony. And what is it going to do? Are we going to have a long line of people that are going to continue to request this? Should people be convicted on junk science or science that people don't believe in? Okay. So this just came out 2 days ago, I believe. And this is from Louisiana. This is the state v. Jimmy Duncan in parish of Wichita. I'm not sure how to say that. Okay. So let's talk about this. All right. So they say here, this is the Supreme Court's opinion. Defendant Jimmy C. Duncan was convicted of the first-degree murder of 23-month-old Haley Olivo, a violation of Louisiana Revised Statute 14:30, and he was sentenced to death. This court affirmed the conviction and death sentence in State versus Duncan 99-2615 on 2001 is what it looks like. And when I went searching for this document, I did see their original denial. Okay. And so it looks like this occurred in 99. Now, during post-conviction proceedings, Duncan raised claims of factual innocence pursuant to Louisiana, not sure what that's the rules of criminal procedure, and ineffectiveness of counsel, among other claims. The trial court granted relief, setting aside his conviction and sentence and granting relief under both the Louisiana rules and factual innocence under those statutes. Says, for the reasons set forth below, in light of the exceptional circumstances here, we affirm the trial court's finding that Duncan carried his burden of proof under the Louisiana court rules and is entitled to relief. Okay. He carried his burden. He met his burden. He proved what he had to prove. They say because we find no abuse of discretion, that's what the judges decided or what the judges did. In the trial court's grant of relief, we pretermit discussion of Duncan's remaining claims. So here's the factual background. The evidence presented at Duncan's 1998 trial is summarized in State v. Duncan and is more fully developed in the record before this court. To place the post-conviction evidence in context, we first summarize the trial evidence relevant to post-conviction review. So they're saying they're only going to talk about the things relevant to what we're talking about here, his post-conviction relief, including both evidence discussed in Duncan 1, I believe that's the first time it came for review, and evidence contained in the trial record, but not addressed in that opinion. Okay, so it sounds like in the second part, the second review, they added some more information. So they say, in short, at trial, the state theorized that Duncan violently attacked and bit Haley, raped her, then drowned her, and staged the scene to avoid detection. The defense theory was that Haley, who had been taken twice to the hospital in the preceding months for possible seizures, drowned after suffering a seizure in the bathtub. Okay, that's the defense theory. The defense also theorized that any assault was committed by someone else. We then turn to the evidence introduced at the post-conviction hearing. Duncan argues his newly presented evidence does not merely impeach isolated trial testimony, but instead entirely undermines the factual premises on which the state's theory depended, okay? So more than just saying a witness was not credible, so the jury shouldn't have believed them or the jury shouldn't have been allowed to hear them, they're saying that the whole premise that the state based their case on, which we're going to talk about, is this bite mark evidence, right? That's their theory, makes the whole thing need to go away. Okay. And here we have subsection 1. It says the trial court granted Duncan relief pursuant to his factual innocence claim, and toss out the conviction versus factual innocence are two different things. Factual innocence is the high bar, okay? That means there was nothing. It's not a court procedure. It's not a rule that didn't get filed. It is factual innocence. Nothing to show you did it, okay? So it says the trial court found that there was, quote, new, reliable, and non-cumulative evidence that would be legally admissible at trial and that was not known or discoverable at or prior to trial, end quote. Okay. And that this evidence, when viewed, quote, in the light of all the relevant evidence, end quote, proves by clear and convincing evidence that had the new evidence been presented at trial, no rational juror would have found Duncan guilty beyond a reasonable doubt. Okay, that's pretty strong language there, right? So they continue. There has been considerable focus on two of the state's key experts, including their involvement with multiple wrongful convictions. We don't like hearing that, do we? And many convictions involving their work have been vacated. Duncan points to new evidence seriously undermining the reliability of the forensic work of those experts, post-trial developments in bite mark analysis, and pediatric forensic pathology. Expert testimony that Haley's death was more consistent with accidental drowning than forcible drowning, and evidence contradicting a jailhouse informant's account of his alleged confession. Sounds like some nasty business there, huh? Okay. Duncan's 1998 trial. In December 1993, Duncan was 25 years old and shared an apartment in West Monroe with his girlfriend, Allison Olivo, and her 23-month-old daughter from a prior marriage, Haley Olivo. It has never been disputed that Haley drowned on December 18, 1993, while she was in Duncan's care. Though the state initially contemplated charging Duncan with negligent homicide, after Haley's autopsy, he was charged with first-degree murder. Allison testified that when she left for work at approximately 8:30 a.m. on the morning of December 18, 1993, Haley was alone with Duncan and she appeared healthy and in good spirits. Around 10:30 a.m., Duncan knocked on the door of his neighbors, Floyd and Wynette Bennett, carrying Haley's lifeless body wrapped in a towel. While Mr. Bennett attempted CPR, the Bennett's son called 911 and an ambulance was dispatched. Both Mr. and Mrs. Bennett described Haley as blue and cold. Neither recalled seeing any blood on Haley or in the white towel in which she was wrapped. Okay. So it says down here, because mother and daughter share a last name, we refer to them as Allison and Haley. Mr. Bennett also testified that between 9:45 and 10 a.m., he saw Duncan walk to the corner store and return smoking a cigarette, although the lead detective testified that the store clerk did not recall Duncan coming to the store. So I don't know what that has to do with negligence, maybe the word negligent. We'll see if they talk about that. Haley was intubated in the ambulance and again in the emergency room, but despite extensive efforts to revive her, she was pronounced dead at 11:15 a.m. One of the treating physicians, Dr. Charles Norwood, testified to observing, quote, severe, end quote, wounds to her anus. Although he expected to see blood or blood clotting, none was present, leading him to believe the area had been, quote, cleaned up, end quote. Duncan gave multiple statements explaining that while Haley was taking a bath, she defecated in the tub, so he cleaned her and the tub, then placed her back in fresh bath water. He said he was washing dishes when he heard splashing, and when he checked on Haley, he found her unresponsive. After unsuccessfully attempting CPR, he ran next door for help. During the second police interview, the day Haley died, after being confronted with Haley's anal injuries, Duncan stated that when he removed Haley from the tub, he, quote, grabbed her by her butt and by her neck, end quote, shook her, and tried to perform CPR. He also said that when he cleaned Haley after her early accident, he washed, quote, around her little butthole, end quote. Detective Chris Sasser, who led the investigation, visited the residence approximately 6 times and photographed the scene. He acknowledged that much of Duncan's account, quote, checked out, end quote. Detective Sasser testified that he searched, quote, every conceivable area, end quote, of the house where there could be blood, but he found no blood, no evidence of cleanup, and no freshly washed clothing items. He also used a blacklight to search for semen and found no evidence of semen anywhere. Testing of Duncan's blood and urine, clothing, and a diaper collected from the bathroom revealed no blood, seminal fluid, or spermatozoa, and Duncan's samples were negative for alcohol or controlled substances. Based on the initial investigation, Detective Sasser recommended charging Duncan with negligent homicide. Now, are you thinking what I'm thinking? What's it sounding like here? What is the detective thinking? What would you be thinking? Okay. And it sounds like that story, like, how did the injuries arrive? But we've got no evidence to back up those injuries. Okay. Who, what, when, where, how. Okay. So he said, all he said was we got negligent homicide. Haley's autopsy altered the direction of the investigation. Okay. So they were looking for all this type of stuff. No evidence of a cleanup, semen, feces, nothing. Okay. Because it sounds to me, in my mind, it sounds like something recent would have happened. But the detective can't find anything. Okay. Now remember, we've got blue and cold. Just saying. Okay. Now, Haley's autopsy altered the direction of the investigation. Haley's body was transported from the hospital to the morgue in Jackson, Mississippi. Now let's back up because we've got this other comment was Dr. Charles Norwood. Okay. So he was in the ER. Okay. That evening, Detective Sasser received a call from Dr. Hain, who reported injuries he observed on Haley's body. Based on Dr. Hain's subsequent report, the charge was upgraded from negligent homicide to first-degree murder. It says here, Detective Sasser, along with other law enforcement personnel, attended the autopsy. He recalled that blood samples were taken and a rape kit was completed during the autopsy. The rape kit was analyzed and no seminal acid phosphatase or spermatozoa were detected. Haley's blood samples were stored in the wrong location and disposed of before any testing was performed. That happens so much more than we think, okay? All right. It says here, this is a quote from, it looks like the prior review. The only direct link the prosecution was able to make between the victim's injuries and the defendant was premised on the bite mark evidence, okay? So while we have these reported anal injuries, they can't find anything to tie it to it. And we don't know what Dr. Hain found, okay? We just heard what this ER doctor found, okay? At trial, Dr. Hain testified that Haley suffered, quote, significant acute injuries, end quote, at around the time of death, including abrasions and bruises on her cheeks, lips, frenulum, scalp, jaw, neck, extremities, belly, knee, and ankle. Because he believes certain marks on Haley were, quote, manifestations of a bite mark, end quote, he sought assistance from forensic odontologist Dr. Michael West and requested that Detective Sasser obtain molds of Duncan's teeth. Regarding the source of the alleged bite marks, Dr. Hain testified that, quote, to a reasonable medical certainty, end quote, the marks on Haley's cheeks did not come from removal of adhesive tape used during the intubation. Okay, that's interesting. Although Dr. West performed the bite mark examination, the state did not call him at trial. The state instead called forensic odontologist Dr. Neil Reisner, who explained that he was testifying because Dr. West had been sanctioned by the American Board of Forensic Odontology, ABFO, for overstating his credentials and, quote, describing pattern injuries that were not due to teeth, end quote. That sounds kind of janky, right? Like, you got to have one guy testify because the other guy got in trouble. Okay, this is why it's very important as an expert to maintain integrity or whatever you want to call it, okay? And we don't know what happened there. We're just reading this. We don't even know if that's true. We just know what they're saying, right? Okay. Dr. Reisner testified that, quote, within a reasonable medical dental certainty, end quote, the marks on Haley's cheek and neck, quote, matched, end quote, or were consistent with Duncan's lower teeth, and the mark on her elbow was consistent with Duncan's upper teeth. The defense called forensic odontologist Dr. Richard Suvarayan, these names, who disagreed with Dr. Reisner and testified he identified no bite marks in the photographs of Haley he reviewed and concluded the abrasions on Haley's face resulted from removal of adhesive tape. He noted that if there had been bite marks, they would have been observed by emergency room staff. He questioned, I'm just wondering, like, was the tape over the area and then they took the tape off? He questioned why Dr. West did not perform certain standard ABFO procedures, such as impressions, saliva samples, and bite prints with print powder. The defense's forensic pathologist, Dr. Robert Kirshner, also testified to his conclusion that, quote, there are no bite marks on this child, end quote, and he was, quote, quite surprised to learn that someone was going to come in and testify that, in fact, there were bite marks, end quote. The sexual assault evidence. The state's theory of sexual assault, so now they mentioned it was a drowning, right? So now we're hearing sexual assault. It says it rested principally on the testimony of Dr. Hain and Dr. Edward Gustafson. Dr. Hain described Haley's anal injuries as, quote, severe tearing, end quote, which he testified could cause life-threatening blood loss, although he acknowledged on cross-examination that he found no evidence that blood loss had occurred. Did they test the tub? He testified that although there was bleeding in the tissue, there was no bleeding on the skin surface of the anus or mucosal surface of the rectum, which indicated the area had been washed. He concluded the injuries were, quote, consistent with, end quote, penetration by an adult male penis. Dr. Gustafson, an expert in pediatrics and intensive care pediatrics, did not examine Haley's body, but relied on photographs and medical reports. Reviewing a photograph of Haley's anus, he testified it was, quote, the worst anal case of sexual abuse, end quote, he had ever seen. He described the, quote, anal tears, quote, as, quote, over a quarter-inch deep, end quote, and, quote, at least an inch long, end quote, and testified Haley would not have stopped bleeding while alive and would have died of blood loss or hemorrhaging. It just sounds awful, doesn't it? Um, did they measure her blood volume? Did they do that? Ugh. He testified that within reasonable medical certainty, Haley had been raped by an adult male penis and there was no other explanation for her injuries. The defense's forensic pathologist, Dr. Kirshner, disagreed with the state's experts regarding the extent and implications of Haley's anal injuries. He testified that a photograph of Haley's anus showed lacerations, but no evidence of internal injury that would have been caused by full penetration of an adult penis. He testified these injuries would cause bleeding, but not enough to bleed to death. Though he disagreed with the state on these points, Dr. Kirshner opined on cross-examination that Haley's death was a homicide. So even the defense expert is saying homicide. Dr. Hain determined that Haley's cause of death was consistent with freshwater drowning. He testified that a contusion on her head may have been caused by a, quote, a thumb or finger pressing down on the back of the head, end quote, and markings on her cheek and neck were consistent with someone holding her head underwater. So maybe that's they're talking about. So when you have that, when you get intubated, right, they tape it. So you're going to have tape here. So they're talking about these abrasions. So abrasions, my hands are backwards, but I think that's where they're going there. Markings on her cheek and neck were consistent with someone holding her head underwater. He also testified he saw nothing in the autopsy indicating the possibility of a pre-death seizure. Okay, now I don't know if seizures leave, like when you have a heart attack, they can test you and you get, you have stuff in your blood. Okay, they can tell chemical reactions and I don't know if it's hormones or whatever that get secreted. They can tell if you're having a heart attack, okay? So this would be interesting to know if anybody knows. Can they tell chemically or whatever if there was a pre-death seizure? Dr. Hain estimated that Haley had been dead for quote, approximately 45 minutes to an hour or even slightly longer, end quote, before arriving at the hospital, supporting the state's theory of an attempted cover-up. The defense theory, by contrast, emphasized Haley's seizure history and the possibility she drowned after suffering a seizure in the bathtub. Allison testified that Haley had suffered 2 seizures during her life, including one incident about a month before her death, in which Allison found Haley, quote, stiff as a board, end quote, with her eyes, quote, rolled up in her head, end quote. Haley went limp and stopped breathing, prompting Allison to take her to the hospital. Dr. Norwood, I think that's the same guy, right, testified that he treated Haley for a suspected febrile seizure or a possible reaction to medication on that occasion. Dr. Kirshner testified people with seizure activity, quote, have a very high risk of drowning in bathtubs, end quote, though, as noted above, he ultimately testified Haley's death was due to homicide. That's interesting. So as a defense attorney, like we're just, looking at both sides, as a defense attorney, would you, if you felt that your expert was going to determine it a homicide anyway, but you thought that they had some good information, would you risk it and put that expert on? What do you think? Let me know. All right, now we have a jailhouse informant. The state also called Michael Cruz, who briefly shared his cell with Duncan at the Wichita Parish Jail. Cruz testified that on or about December 28, 1993, he woke to find Duncan, quote, ranting and raving, end quote, about his innocence. According to Cruz, Duncan was sobbing and rambling, telling Cruz that, quote, the baby was pointing at his penis and that he said something about a bottle or a bauble, end quote. Then Cruz testified Duncan said, quote, it must have been the devil in him because the next thing he knew, he blacked out again, and when he came to, he was trying to have sex with the baby, end quote. Cruz further testified that Duncan said that, quote, he couldn't get the baby to be quiet, end quote, and, quote, all he wanted was for the baby to stop. So here we have number 5. Although Haley's blood was drawn Dr. Hain did not test it for medications or toxins, and as noted above, the blood sample was mistakenly destroyed before trial. Dr. Hain also testified that if Haley had eaten oatmeal for breakfast the morning she died, there would be some present in her stomach or small bowel, and he found none. This was additional testimony supporting the state's cover-up theory. So I'm thinking here that due to the time frame, 9:30, 10:30, whatever, when it happened or supposedly happened, remember we have cold and blue, um, that the oatmeal, they would use the oatmeal. What time does she normally eat breakfast? Because he would have said, and I'm just theorizing, she ate breakfast this morning, everything was normal, she went in to take her bath, and I was washing the dishes and blah, blah, blah. So I think that's what they're trying to say with the oatmeal. Not sure. The jury returned a verdict of guilty as charged and found 3 aggravating circumstances. Duncan was engaged in the perpetration of aggravated rape or attempted aggravated rape. The victim was under the age of 12, and the offense was committed in an especially heinous, atrocious, or cruel manner. Duncan was sentenced to death by lethal injection, and this court affirmed on direct appeal. Okay, that's the case there, the review. Post-conviction proceedings. Duncan filed a pro se post-conviction relief application in 2002 that was supplemented by counsel in 2008 and 2022. The application alleged, inter alia, factual innocence pursuant to the Louisiana rules and ineffective assistance of counsel. Duncan argued that new evidence unavailable at trial undermined the testimony and conclusions of the state's experts, Dr. Hain and Dr. West, whose opinions had supplied the foundation for the state's theory that Haley was bitten, sexually assaulted, and forcibly drowned. He also argued that Cruz's testimony had been contradicted by another former cellmate. The trial court held a 6-day evidentiary hearing in September 2024. The post-conviction evidence was directed principally at the alleged bite marks, the alleged sexual assault, and the alleged forcible drowning. Duncan called University of Mississippi law professor William Tucker Carrington to testify as a legal historian with expertise on wrongful convictions related to the practices of Dr. Hain and Dr. West. Okay, so these 2 doctors apparently have a history of bad or challenged testimony, right? So as an expert, when you get on the stand, a good prosecutor, a good defense attorney should ask you about all your cases. They go back, they look at the testimony, they really scrutinize it because they try to get you thrown out. They challenge you and they try to get you thrown out. So apparently there had been some bad stuff or alleged bad stuff going on with Dr. Hain and Dr. West. So it says, Professor Carrington has authored law review articles and a book about the men and their practices. Now, I had heard that the bite mark evidence was at some point ruled junk science, okay? So that was floating around in my head. But I didn't know any particulars about it and who specifically. There could be a whole host of people involved in this or named or whatever. So Carrington described investigative and judicial findings developed after Duncan's trial concerning Dr. Hain's and Dr. West's work. In summary, Professor Carrington testified that later investigations and proceedings have linked Dr. Hain and Dr. West, it's bad, to unethical business practices, false or misleading representations about qualifications, and a record of at least 6 wrongful convictions connected to their forensic work since Duncan's 1994 trial. That's terrible. With respect to Dr. Hain's business practices, Professor Carrington testified that during portions of the relevant period, including when Haley's autopsy was performed, like I saw the number, Dr. Hain was conducting 800 to 1,000 autopsies each year, far exceeding the National Association of Medical Examiners guidelines of 250 autopsies. Well, if you have 365 days a year, you're only supposed to, 20 Um, if you worked, 50 times 5, yeah, that's 250. So that's one a day. Okay, that's one a day because you have to write your reports and you have to do other stuff. I mean, autopsies can take a lot of time. So, okay. He questioned how, quote, any sort of human being could be doing that volume, end quote. Just think about, have they reviewed all those autopsies? Have they gone back? Imagine if that was one of your loved ones. According to documentary, so maybe there's I don't know if they mean documentary like written proof or documentary like video documentary. According to documentary evidence, Professor Carrington reviewed, this generated approximately 1.5 to 2 million annually. Professor Carrington also identified serious errors in Dr. Haynes' autopsy reports, including unsupported conclusions, failure to preserve tissue samples, and poor documentation. Unsafe. Professor Carrington also testified about the working relationship between Dr. Hayne and Dr. West, explaining that as a matter of practice, Dr. Hayne would frequently perform an autopsy, note some sort of, quote, pattern injury, end quote, then refer the case to Dr. West for his expertise in bite mark, quote, matching, end quote, through his, quote, direct comparison, end quote, method or videotape enhancement. He testified that their working relationship was, quote, common knowledge, end quote, and that both had financial incentives to continue that relationship. Oh, goodness gracious. Okay, let's see. Okay, so it looks like he wrote a book. Evidence admitted in connection with Professor Carrington's testimony includes 2 law review articles he wrote and excerpts from the book he wrote about the men, including related citations. The book's called CSI Mississippi, The Cautionary Tale of Mississippi Medico-Legal History. Okay, that would be, I don't know if that's the book or Tucker Carrington, Mississippi Innocence, The Convictions and Exonerations of Levin Brooks and Kennedy Brewer, and the Failure of the American Promise. Okay, that is supposed to be articles. Radley Bacco and Tucker Carrington, the Cadaver King and the Country Dentist, a true story of injustice in the American South. Goodness gracious. I'm not sure which one is the book. Those of you that know citations better, I'm not sure. We can Google. Okay. Professor Carrington recalled an autopsy report authored by Dr. Hayne that described the weight and measurement of a spleen in a man whose spleen had been removed years before he died. Oh my God. In another report, Dr. Hayne described a prostate in a female baby. Oh, goodness. Documentation underlying Professor Carrington's testimony describes additional, quote, egregious mistakes, end quote, in Dr. Haynes' autopsies, including one where he noted in his report that, quote, he had removed and examined the decedent's ovaries and uterus, end quote, but the victim was male. Sounds like, what do you call it, templates. An excerpt from his book, admitted during Professor Carrington's testimony, notes that the exact nature of the relationship between Dr. Hayne and Dr. West is unknown, and that both men, quote, apparently lost or destroyed most of their financial records, personal records, autopsy records, and correspondence with police and prosecutors over the years, end quote. Whew. Okay. According to Professor Carrington, Dr. West's, quote, direct comparison, end quote, method involved taking the, quote, dentition of a suspect and trying to determine whether or not it matches the purported bite marks, end quote, on the victim. Dr. West's specific method involved pressing a dental mold into the skin of the victim onto, quote, what he believed or claimed were bite marks, end quote. Professor Carrington testified about multiple wrongful convictions attributable to the work of one or both doctors. He particularly noted 2 related Mississippi cases in which Dr. Hayne identified supposed bite marks. Dr. West confirmed and, quote, matched, end quote, them to defendants using his, quote, direct comparison, end quote, method, and the defendants were later exonerated by DNA evidence. Oh. Sorry, guys, like this is like not good. Don't like any of this. As this court noted in its original opinion, quote, the only direct link the prosecution was able to make between the victim's injuries and the defendant was premised on the bite mark evidence, end quote. Duncan called 2 experts at the post-conviction hearing to testify about Dr. Michael West's work in connection with Haley's case, including a video in which Dr. West performs his, quote, direct comparison method using Duncan's dental molds on Haley's body. Duncan first called Dr. Lowell Levine, an expert in forensic odontology and one of the founders of the American Board of Forensic Odontologists. Dr. Levine testified that Dr. West's, quote, direct comparison, end quote, method was never approved by the ABFO and is something he only knew Dr. West to have performed. Because this method involves placing dental molds on the skin, he explained, it risks creating evidence that is not there, destroying or compromising existing evidence, and contaminating the body with external evidence. I was thinking about that, about how, pushing down or whatever, because it's dead skin, right? So it probably doesn't have the suppleness or whatever. I don't know what it would do to it. Okay, so here's some cases here. Number 10, another thing of factual innocence. And then Dr. Levine was approached by the district attorney's office, to consult on Haley's death. After learning of the examination had been performed by Dr. West, he declined to do so. So maybe they were going to ask him to come in and testify about supporting Dr. West's work, and he said no. Okay, we have that right. Yeah. No. He explained, instead of pressing dental molds into a victim's skin to make comparisons, the ABFO developed measuring tools, including a special ruler, to be used with, quote, precise, exact, life-size photographs, end quote. Dr. Levine also explained that current ABFO guidelines do not recommend an odontologist use the terms, quote, match, end quote, or, quote, within a reasonable dental certainty, end quote, although those terms were permissible in 1994. Today, an odontologist can say at most that he, quote, cannot exclude, end quote, a person from having made the marks. The West video was played for the trial court, and Dr. Levine testified he was, quote, appalled, end quote, to watch Dr. West, quote, pushing the teeth into the tissue with force, end quote. He testified that Dr. West's actions in the video, quote, destroyed, end quote, and, quote, compromised, end quote, the evidence. He further explained that the ABFO requires an odontologist to maintain a photo log tracking each photo taken of the deceased, but Dr. West did not do so. As a result, there is therefore no way to determine whether the photographs relied on by Dr. Reisner was taken before or after Dr. West pressed the molds of Duncan's teeth into Haley's skin. Good point. Good point there, right? He also opined that Dr. West's report, which consisted of a one-page letter, was, quote, totally inadequate, end quote, because it stated conclusions without any basis or a description of the technique used to come to those conclusions. With respect to the West video and bite mark evidence generally, Duncan also called Dr. Adam Freeman, a dentist and expert in forensic odontology. Dr. Freeman was certified by the ABFO in 2009 and rose to become president of the organization. He testified to the evolving views of bite mark examination within the forensic odontology community. Dr. Freeman testified that the scientific understanding of bite mark identification changed significantly in 2009 when the National Academy of Science published a report on the status of forensic science in the United States. Yes, I remember that. Things kind of went, junk science became a term. The NAS report concluded that bite mark evidence lacked a scientific basis, that skin is a poor medium for capturing pattern injuries, and that bite mark analysis is prone to bias. As chair of an ABFO bite mark committee, Dr. Freeman conducted studies asking certified forensic odontologists to determine whether injuries depicted in photographs were human bite marks. Dr. Freeman described the results of his study as, quote, completely devastating, end quote, because even the top board certified forensic odontologists in the country could not agree on whether a bite mark was a human bite mark. Oh my goodness, it's just giving me the creeps. Turning to this case, Dr. Freeman and another forensic odontologist reviewed the evidence and drafted a joint affidavit. They worked independently and were not aware of each other's conclusions before drafting the affidavit. As to the mark under Haley's right ear, they found it was a, quote, diffuse bruise, end quote, without class characteristics or individual characteristics to meet the ABFO definition of a bite mark. As to the mark on Haley's elbow, they again found it to be a diffuse bruise. Dr. Freeman testified, quote, it is scientifically indefensible to state that that is a human bite mark and that those are the teeth of a specific individual, end quote. Dr. Freeman was shown the West video and noted that, quote, you can see where Dr. West is actually pushing the cast into the skin of this child, end quote. He described Dr. West's, quote, direct comparison, end quote, method as, quote, an indefensible method that nobody else in the ABFO used, end quote. Dr. Levine, Dr. Freeman testified that by performing this method, Dr. West was destroying evidence while also, quote, creating marks, end quote, on the skin. Okay, so here we have number 12. Dr. Freeman similarly testified about 3 additional bite mark studies, which all had poor results. Blah, blah, blah. National Institute of Standards Technology, NIST, okay. According to the NIST report, NIST is like a standard. According to the NIST report, a bite mark cannot be diagnosed or accurately transferred to the skin. Skin is a poor recording medium, and the evidence is of such poor quality, it cannot be relied on to either include or exclude a person as the biter. And this was the NIST report, junk science. Okay, that's remember, junk science. I remember huge things, junk science. Those were the words. Also, it says defense expert Dr. Judy Melnick's pathology review is consistent with this conclusion. She testified, quote, nothing resembling a bite mark is visible in the available photographs and video, end quote. She talked about marks on the tape, on Haley's face aligned with the tape, and that Dr. West's, quote, direct comparison, end quote, method damaged the skin in a way that can make non-bite mark injuries appear consistent with bite marks. Who is this? Is Dr. Freeman. Okay. So Dr. Freeman further testified that the angles at which Dr. West held the mold were a, quote, physical impossibility, end quote, for a human jaw, quote, unless we become snakes where we can dishinge our joints, which we cannot. So I'm guessing that's some sort of, where we do that. So it, we only have our teeth, so it's going to be at a certain area instead of, being able to, what they're talking about, unhinge the jaw to bite in a different area. He explained that although some members of the ABFO continue to support the use of bite mark evidence, he said none would endorse Dr. West's procedure. This is important in the context of the trial evidence of Dr. Suvaran opining that bite marks did not appear in photos he reviewed. The state called one witness at the post-conviction hearing, a former detective, Chris Sasser. Relevant to the issues presented to the court, Detective Sasser testified that he observed Dr. West place Duncan's dental impressions on Haley's body, but he denied that Dr. West made any marks that were not already there. The autopsy and the alleged sexual abuse evidence. As this court noted in its original opinion, quote, a thorough search of the crime scene revealed neither blood nor semen, nor was any blood found on defendant's body or attire, end quote. Despite the absence of such evidence, the original trial testimony was that Haley had been a victim of severe sexual abuse. At the post-conviction hearing, Duncan called Dr. Robert Bucks, a board-certified anatomical, clinical, and forensic pathologist, to testify regarding his review of this case. So we're going to say, we're going to read this down here. I don't know. There's nothing really there. Dr. Butts, unlike Dr. Hain, Dr. Bucks relied in part on Detective Sasser's, quote, excellent investigation. Dr. Butts rejected Hain's conclusions regarding both forcible drowning and sexual assault, testifying that Dr. Hain got a string. Sorry, guys, I got a string here. Dr. Butts testified that Dr. Haynes' autopsy of Haley was, quote, inadequate, end quote, sloppy, end quote, below the standard of care, end quote, and misrepresented findings. Dr. Bucks noted the absence of photographs, tissue samples, or microscopic slides, as well as the contradiction between Dr. Haynes' observations and conclusions. Dr. Bucks testified that the pathology seen in Haley's anus and rectum was not due to trauma or rape, but it was attributable to inflammation related to disease, diaper rash, rough washing, or hard stool. He explained that the scientific understanding of factors potentially indicative of sexual abuse has changed since 1993, noting that a, quote, consensus, end quote, emerged around 2007 to 2008 that a dilated anus alone is not necessarily indicative of sexual abuse, but instead, quote, means nothing, end quote, and is, quote, seen all the time, end quote. He further testified at trial that defense expert Dr. Kirshner erroneously relied on Dr. Haynes' findings without personally reviewing or analyzing any tissue samples or physical evidence. So that's a huge discrepancy there based on what they were telling us, right? Initially. In his report, which was entered into evidence at the post-conviction hearing, Dr. Butts opined that aspects of Dr. Haynes' documentation failures, quote, suggest that at least some of his observations were likely fabricated, end quote. Oh my goodness. So with no body to create a new autopsy or to perform a new autopsy, what are you going to do? Right? Because here, like this, they're going to say, he explained that tissue sampling, internal organ analysis, and microscopic examination of Haley's rectum and anus could not have been completed. And they were not, he says, okay, they could not have been completed in the available time. So that's problematic. And were not adequately documented, including lacking any depth measurement for purported lacerations. So he didn't even look at it? That's crazy. With respect to the autopsy and sexual abuse evidence, Duncan also called Dr. Judy Melnick, a board-certified expert in anatomical clinical forensic pathology, who explained that the doctors who testified at trial erred in numerous ways. And number 16, it says, Dr. Buck's report goes into detail regarding Dr. Haynes' qualifications, noting he did not have the appropriate credentials to be relied upon to make the conclusions that he did in this case. Goodness gracious. Okay. Now we've got Dr. Melnick found that Dr. Haynes' work, quote, suffered from terrible methodological failures, end quote, and his methods were and interpretation were, quote, out of line even for what was acceptable in 1993, end quote. She also testified that more recent scientific studies have shown that natural disease, accidental injury, stooling, and other non-abusive conditions can produce anal findings that, quote, mimic, end quote, injuries once attributed to sexual abuse. Since the 80s and 90s, certain studies have found what appeared to be trauma or sexual abuse were instead medical conditions or post-mortem changes. Crazy, huh? With respect to Haley, Dr. Melnick's report stated that the angel injuries were superficial and consistent with, quote, toddlers who are toilet training when a caregiver attempts to clean them following a toilet accident. As Duncan reported doing, she further testified that penetration of a toddler anus by an adult male penis would have caused, quote, devastating internal injuries with hemorrhage, end quote, neither of which were documented at the autopsy. Moreover, the anal dilation observed at the hospital is a, quote, common postmortem change, end quote, and not an indication of trauma. Now, it's a lot of TMI, but in certain cases, after death, there is a, okay. I didn't know that it was related to dilation or whatever. Like, we're going to leave that there, but hopefully you understand what I'm saying. Okay. To that end, Dr. Melnick disagreed with Dr. Gustafson's conclusion that Haley's injuries were so severe as to result in extreme blood loss, pointing out that no such blood loss was documented in her medical record. So I'm assuming they weigh it or volumize it or whatever. Additionally, and critical to the outcome here, there was no evidence of blood loss or cleaning at the residence despite a thorough and well-documented search. Dr. Bucks also addressed cause of death and opined that Haley's death, sorry, I can't talk, you guys, opined that Haley's cause of death was accidental drowning. He testified that if someone had held Haley's head underwater, he would expect to see injuries to the front of her body, particularly on her forehead, nose, shoulders, or knees. In this case, however, he saw no evidence of forced drowning causing death, noting specifically that Dr. Haynes' autopsy documented no such injuries and that injuries to her face were best explained as having been made by the medical tape used when she was intubated. He also testified that the documented injuries were consistent with Duncan's account of cleaning Haley after the toiling incident, removing her from the tub, and attempting to revive her. Dr. Melnick also disputed this number 17. Dr. Haynes' testimony that the absence of inflammation showed the anal injuries must have occurred approximately 30 minutes before Haley's death. She explained that the proper methodology for aging injuries involves using special stains on tissue slides, not simple observation, and there is no indication Dr. Haynes performed this procedure. In any event, the earliest acute inflammatory activity is seen at 4 hours after injury, not 30 minutes. Man, a lot of stuff here. Having a good autopsy, right? Dr. Melnick also addressed the forcible drowning theory, testifying that Dr. Haynes' conclusion of forcible drowning was, quote, wildly inappropriate, end quote. She opined that Haley died from complications of drowning, likely due to epilepsy that had possibly been exacerbated by a recent head trauma. She explained that Haley had suffered several skull fractures a few weeks before her death when a piece of furniture fell on her head. She explained that though the head trauma was known in the 1990s to increase seizure risk, scientific understanding of post-traumatic epilepsy has since advanced. She described Dr. Haynes' conclusion that a bruise on Haley's head or neck was a thumb mark from forcible drowning as, quote, way off and beyond what would even have been acceptable testimony at trial. As to the time of Haley's death, Dr. Melnick explained in her report that Dr. Haynes' testimony that Haley was dead for 45 minutes before she arrived at the hospital is belied by the absence of rigidity and a body temperature of 98.6 degrees. Okay, that tells you. Rigor mortis comes in at starts to form. That's rigidity. Her report noted that determining the time of death by touching skin is, quote, subjective, end quote, and, quote, unreliable, end quote, especially in a child who had been, quote, naked and immersed in water, end quote. Jailhouse informant evidence. Duncan called licensed private investigator Don Carter, who was hired by post-conviction counsel in 2008 to take statements from Cruz and Michael Lucas, a former cellmate of Duncan and Cruz. Cruz hung up when Carter contacted him. Lucas, who had since become unavailable to testify due to a stroke, signed a written statement after meeting with Carter. In that statement, Lucas recalled that Duncan denied responsibility for Haley's death and that he never saw Duncan have a conversation with Cruz. Quote, all I ever seen was Michael hound him about his charge, never a conversation, end quote. Carter testified that Lucas recalled Cruz hassling Duncan about his charge and Duncan crying and repeatedly saying, quote, he did not do it, end quote. Okay. So was somebody pushing to try to make a deal? Okay. They also say here, number 18, that the state and Duncan's counsel had a stipulation to exclude certain evidence related to Haley's medical history, including the injuries and hospitalization related to this accident. I don't know what that is about. 19, Dr. Melnick explained that Dr. Haynes' comment that, quote, the brain showed no evidence of seizure activity, end quote, did not make sense because a seizure is an electrical disturbance in the brain. There is no electrical activity in a dead brain. Okay, so I guess there's no mechanism. I remember I was asking, there's no mechanism to tell. Ineffectiveness of counsel evidence. Duncan's final witness was James Boren, who was offered and accepted without objection as an expert in capital criminal defense. Mr. Boren opined that trial counsel failed to, quote, develop a coherent defense theory, in part by conceding Haley was sexually assaulted while denying it was Duncan. Adequately investigate viable defenses, provide experts with critical evidence sufficient to form reliable opinions, particularly the West video and information from Haley's prior hospital visits, impeach Cruz's alleged confession testimony, and address a disqualifying conflict of interest. So it's very important about letting the experts do their work and giving them what they need. On April 23rd, 2025, the trial court granted Duncan's post-conviction claims of factual innocence and ineffectiveness. Ineffective assistance of counsel, and on May 19, 2025, vacated his conviction and sentence. The trial court concluded that Duncan carried his burden, that means he met his burden, noting, quote, a wide divide between what was presented at the original trial of petitioner and what could be presented now. We've got something here in 20. This is about the private investigator. The conversation was not recorded, but he did get to review the statement. Something about hearsay. Okay. In written reasons, the trial court found Haley drowned in the bathtub on December 18th, 1993. Okay, so this is the trial court found. So this is the ruling. This is the facts from the court now. The trial court found Haley drowned in the bathtub on December 18, 1993, after having suffered seizures and injuries in the weeks before her death. The court noted that Duncan consistently told police he may have accidentally injured Haley while cleaning her after she defecated in the tub, and that the initial investigation did not reveal blood, semen, signs of a struggle, or evidence of a cleanup. Neither the medical professionals, Child Protective Services, nor the coroner's office reported any concerns about bite marks. The court also noted that Duncan's statements were largely consistent with Detective Sasser's investigation, and that the charge was upgraded from negligent homicide to first-degree murder only after Dr. Hain and Dr. West reported their conclusions concerning possible bite marks. Against that factual background, the trial court found that Duncan's conviction turned substantially on forensic evidence offered by experts whose reliability, quote, appear questionable at best, end quote. The court described the West video, noting that Dr. West's, quote, direct comparison technique, end quote, has been, quote, seriously questioned, end quote, and that the video showed him, quote, forcibly thrusting, end quote, Duncan's dental molds into areas of Haley's face and body, quote, in a rather disturbing manner and to a rather disturbing degree, end quote. The court also found serious problems with Dr. Hain's autopsy and conclusions of anal rape and forcible drowning, particularly given the lack of physical evidence supporting sexual assault, bleeding, or cleanup. The court relied on the post-conviction testimony of Dr. Levine, Dr. Freeman, Dr. Bucks, Dr. Melnick, Professor Carrington, and Detective Sasser. It emphasized that bite mark science generally and Dr. West's method specifically had been seriously undermined. Dr. Bucks found Dr. Hain's autopsy, quote, inadequate, end quote, sloppy, below the standard of care, with failures in its documentation, and, quote, professional independence issues, end quote. Dr. Melnick, quote, convincingly testified, end quote, Haley died as a result of accidental drowning rather than homicide, and Professor Carrington described serious reliability concerns surrounding Dr. Hain and Dr. West, including his testimony that Dr. Hain provided, quote, untruthful testimony, engaged in unethical business practices, and was, quote, untruthful about his credentials, end quote. Goodness. The trial court also found compelling Detective Sasser's testimony that he, quote, he found no blood, no signs of struggle, no cleaning rags, and no cleaning agents, end quote, at the scene, which the court stated, quote, discredited, end quote, the state's assertion that Haley suffered massive blood loss. The trial court also granted relief under the rules, relying principally on Mr. Boren's testimony that the trial counsel failed to investigate and present available evidence. Happens all the time. failed to develop a coherent defense strategy, coherent defense theory, and failed to disclose a conflict of interest. What was that? The trial court granted post-conviction relief and set aside Duncan's conviction and sentence. It additionally authorizes the state to take further action, whatever that is. After the trial court granted relief, the state filed a writ application, and this court granted the writ. Thereafter, the trial court set bail, and Duncan was released from custody with the support of both Haley's paternal and maternal family members. So, this is their analysis. Okay, this is interesting. Factual innocence. This case presents the court's first opportunity to apply the rules which governs post-conviction claims of factual innocence. The burden of proof rests on the petitioner, and relief can only be granted on the grounds set forth in the rule. Okay, so it says in Louisiana, it's a two-step process. You have to present new, reliable, and non-cumulative evidence. So I think it's each thing separate on its own, okay? That it doesn't have to add up. It also says that they have to present evidence that satisfies all the criteria in subparagraph A. And when viewed in the light of all the relevant evidence, including evidence admitted at trial, no rational, that's the word there, no rational juror would have found the petitioner guilty beyond a reasonable doubt. And it also says this rule was amended in 2025 to say that the state has no burden of proof in post-conviction proceedings. Okay, they're going through some case law here. They're saying that Professor Carrington's testimony goes beyond mere impeachment of Dr. Hayne and Dr. West, instead providing newly discovered context about how the relationship methods, monetary incentives, and now history of unreliable forensic conclusions bore directly on the evidence. So they said they got the first prong, and then they're talking about all the relevant evidence. So it's not just a review of the new evidence. So they have to go back and look at the whole thing, okay? So they're talking about even though the post-trial evolution in scientific understanding of bite mark evidence and pediatric or forensic pathology may not independently qualify as new, these are all part of all of the relevant evidence. The court says that there's now seriously questionable evidence introduced by Dr. Hayne and Dr. West. They said the state originally planned to charge the defendant with negligent homicide, but only after receiving this information from Dr. Hayne and Dr. West, they upgraded it. So they're saying that considering the trial record, the post-conviction evidence did not merely challenge isolated parts of the state case, nor was this a renewed battle of the experts, which happens all the time. Rather, the post-conviction evidence undermined the core factual premises on which the state depended, that Haley's body had bite marks linking Duncan to a violent assault, and her anal injuries proved sexual abuse and supplied a motive for murder, and that she was forcibly drowned as a result of that assault or its cover-up. Okay, so then because the bite marks were the only link, okay, they're gonna, they talk about that we've read. They also said, okay, we don't even have a sexual assault. The drowning, they said nope, there was no force, no indications of force, and they're saying that that since they found no blood, semen, signs of struggle, cleaning rags, cleaning agents, there was just nothing to support it, okay? So they said in granting relief to Duncan, the trial court recognized the quote, wide divide between what was presented at the original trial petitioner and what can be presented now, end quote. Now, this doesn't only apply to things in science that changes over the years, but think about these cases, and we see on the news all the time where because of pretrial decisions or trial decisions, the jury doesn't get to hear a lot of this stuff. And how much does that impact these cases, right? So they say that, let's see what they say here, because here's my letters I like. Our jurisprudence recognizes that a non-DNA factual innocence claim requires a quote extraordinary end quote high showing that quote undermines the prosecution's entire case end quote. Okay, so they're liking DNA for exoneration. It also says here Haley's paternal family members, so Haley's father's family filed an amicus brief in support of Duncan, stating they, quote, believe fully, end quote, in his innocence and support the grant of relief. Haley's mother, Allison, tested at Duncan's bail hearing in support of his release, asserting that after hearing the new evidence presented at post-conviction, she believes the state, quote, made up, end quote, the case against Duncan. We note these views only to acknowledge the positions of Haley's surviving immediate family members, but they do not factor into our legal analysis. They talk about significant blood loss, which they didn't find that in the autopsy. And then the ineffectiveness of counsel. So they said the trial court did not abuse its discretion in finding that Duncan presented new, reliable, and non-cumulative evidence, which, when viewed in the light of all relevant evidence, proves by clear and convincing evidence that no rational juror would have found him guilty beyond a reasonable doubt of first-degree murder had the new evidence been presented at trial. He met his burden. He's entitled to relief. And there you go. So what do you think? That went all over the place, didn't it? So we started out thinking one thing, at least I did. And then now we've got all these things, okay? So talk about the battling of the experts, right? And vetting people and making sure that stuff is reliable. That's why we have our Fry and Daubert challenges, and these experts get challenged. We've seen it in a lot of cases. We saw it, someone that you would know, the Karen Reed case. My gosh, the experts were all over the place. So this is what I love about this. Is very, very, very interesting. I hope you enjoy it too. If you do, I really would appreciate a subscribe. Don't have to like it. Don't have to comment, although I love your comments. We're here. I'm here operating this channel, trying to get to 1,000 subscribers because I want to be able to donate my time to identifying the over 15,500 unidentified human remains cases across the United States and working on the hundreds of thousands of cold cases across the United States. And I cannot do it without you. So thank you for being here. Thank you for sharing your thoughts, and I will see you on the next one.